Before May 1707, two states recognised under international law existed on the island of Britain: Scotland in the northern part and England in the south. After May 1707, only one state recognised in international law occupied the whole of the island of Britain. How did that come about? The orthodox view, enshrined in legal texts and political rhetoric, is that in 1707 these two independent states entered into an international agreement, followed by acts of their two parliaments, in terms of which both ceased to exist and were reborn as a new state, the United Kingdom of Great Britain. This narrative of a voluntary mutual union is a powerful one. It was championed by English scholars and jurists like William Blackstone in the 18th century, and constitutional lawyer A.V. Dicey and international lawyer Lord McNair in the 20th century. It is also echoed in the 20th century by Scottish legal scholars, such as Professor David Walker of Glasgow University and Professor Sir T.B. Smith of Edinburgh University. It is the view of the constitutional position that has been expressed by the government of the United Kingdom on numerous occasions over many years, and it is a view accepted by the devolved government of Scotland in Edinburgh. In 2022, the Supreme Court of the United Kingdom was called upon to decide whether the devolved Scottish Parliament had the authority to pass legislation providing for a referendum to be held on the issue of independence for Scotland. In her submissions to the court, the Lord Advocate, the chief law officer of the devolved administration, stated the kingdoms of Scotland ceased to exist in 1707. These states no longer exist, having been replaced by the United Kingdom. This explanation of what happened in 1707 is false. Its falsity can be demonstrated by considering the institutions of government, executive, legislative and judicial, in Scotland and England before and after the supposed creation of this new state. The events of 1707 certainly resulted in Scotland's executive government and its legislature ceasing to exist. But was there any parallel in England? Were the governmental institutions of both nations replaced by the institutions of a new state? The answer to these questions is no. England's institutions of government continued in being, completely unchanged, save for their authority being now extended to encompass Scotland. Let's look at the executive government. The events of 1707 undoubtedly resulted in Scotland's national government ceasing to exist. The executive branch of government in Scotland, including but not limited to the Privy Council, was superseded by the existing executive structure pertaining in England, including its Privy Council, with the addition of a Secretary of State for Scotland, an office, however, that was abolished in 1746, Scotland thereafter being managed by the Lord Advocate until 1827, and then by the Home Office in London until the office of Secretary for Scotland was created in 1885 and upgraded to Secretary of State for Scotland in 1926. The institutions of executive government in England changed and not at all after and in consequence of the events of 1707. For England, nothing changed. One of the functions of the executive branch of government is the conclusion of treaties with foreign states. Prior to 1707, both Scotland and England did this. None of Scotland's pre-1707 treaties, including with France, with the Pope, and with various Scandinavian states, was regarded by the new regime and by legal scholars as still valid and binding after 1st of May 1707. By contrast, England's pre-1707 treaties were regarded by the new regime and by legal scholars as continuing in full force and effect, notwithstanding the supposed creation of the new United Kingdom of Great Britain. And England's diplomatic representation in Europe continued uninterrupted. Fresh credentials on behalf of the monarch of the supposed new state of Great Britain were not presented to, nor indeed expected by, the foreign states to which the diplomatic representatives had been accredited. For England, nothing changed. A very telling symbol of this continuity of England is the title adopted by the late Queen, as proclaimed with the advice of the UK government on her accession to the throne in 1952. That title was Elizabeth II, notwithstanding the fact that the first Elizabeth Tudor, reigned over England alone. Had a new state replacing England come into existence in 1707, the late Queen would have been the first monarch with the name of Elizabeth to be its head of state. The use of the second is a quiet but profound admission that the English monarchy, and by extension the English state, continued unbroken. And I may say this was not the first occasion on which that occurred. In the 20th century, there were two kings with the name Edward. One was Edward VII, and one was Edward VIII. Now, before 1707, there had been 6 kings of the name of Edward in England. But after 1707, there were no Edwards until the 2 in the 20th century appeared. If a new state had been created in 1707, Edward VII would have been Edward I, and Edward VIII would have been Edward II. Turning to the legislature, the events of 1707 undoubtedly resulted in Scotland's legislature ceasing to exist. What was the situation in England? Both houses of the English Parliament remained in being, exactly as before, save for the addition to the House of Commons of 45 Scottish members and to the House of Lords of 16 holders of Scottish peerages. All of the traditions, procedures, standing orders, and officers of the English Parliament continued unaltered. It was not even considered necessary to hold a general election or for the Commons to select a new Speaker. For England, nothing changed. The Speaker at the time was, of course, one John Smith, the Member of Parliament for Andover, who is perhaps best remembered for saying, "We have catched Scotland and will bind her fast." The first collection of the legislation of the Westminster Parliament, the Statutes of the Realm, was published between 1810 and 1822. In that collection, the numbering by regnal year and chapter number of the legislation passed by the Parliament continued in an unbroken series before and after the addition of the Scottish members. Thus, the Act of the English Parliament ratifying the Treaty of Union was 6 Anne, Chapter 11. The last act passed by the English Parliament before the new dispensation took effect on 1st of May 1707 was 6 Anne, Chapter 34. The first act passed after the addition of the Scottish members was numbered 6 Anne, Chapter 35. For England, nothing changed. It was only when a new collected edition of the legislation Statutes at Large was published between 1870 and 1878 that the numbering system was changed and acts passed after the admission of Scots to the English Parliament were renumbered, starting with 6 Anne, Chapter 1. The English writer and secret agent Daniel Defoe is reported to have said in November 1706, while the treaty negotiations were proceeding, "The Scots will be allowed to send to Westminster a handful of men who will make no weight whatever. They will be allowed to sit there for form's sake, to be laughed at." What about the judicial branch of government? As far as the judicial branch of government is concerned, for England, nothing changed. At first sight, it would appear from the texts of the Treaty and Acts of Union that equally for Scotland, nothing changed. Article 19 provided that the Scottish courts should remain in existence in all time coming within Scotland, subject, however, to such regulations as might be made by the Parliament of Great Britain for the better administration of justice. And it was also provided that no cases from Scotland be cognisable by the Courts of Chancery, Queen's Bench, Common Pleas, or any other of the English courts in Westminster Hall, and that these courts, these English courts, should have no power to cognise, review, or alter the decrees or sentences of the Scottish courts. Maintaining Scotland's independent court system was particularly important because the law of Scotland was based on the received Roman law of continental Europe and was quite different from the common law of England, built up over the years by the English judges and almost completely uninfluenced by Roman law. But in England, a right of appeal existed in certain circumstances to the House of Lords, sitting as a court, not as a House of Legislature. It, of course, sat not in Westminster Hall like the other English courts, but in the Palace of Westminster. In Scotland before the Union, protestation for remeed of law could be taken from the Court of Session to the Scots Parliament. The Treaty of Union did not explicitly provide for appeals from the Scottish courts, but nor did they expressly prohibit them. And dissatisfied litigants, claiming to exercise the privilege asserted in the claim of right to protest for remeed of law against decisions of the Court of Session, took appeals to the upper house of the Westminster Parliament, where the House of Lords welcomed them with open arms. The court at the apex of the English judicial system was thereby enabled to correct decisions delivered by the Supreme Civil Court in Scotland. So it was that from 1707, the ultimate court of appeal in civil matters in Scotland became the House of Lords. Sitting as a court, it was normally staffed by the Lord Chancellor and any other peer who held or had held high judicial office. Very often the Lord Chancellor sat alone. Between 1707 and 1867, the final Court of Appeal from Scottish civil courts contained not one single judge trained or qualified in the law of Scotland. Lord Erskine, who had been Lord Chancellor in 1806 and 1807, said in a debate in the House of Lords that he knew something of the law, but of Scotch law he was as ignorant as a native of Mexico, and yet he was quite as learned in it as any one of their lordships. In 1858, Lord Cranworth, in a Scottish appeal in the House of Lords, referring to a doctrine of English law that would have applied had the case come through the English court system, said this: "But if such be the law of England, on what ground can it be argued not to be the law of Scotland? The law as established in England is founded on principles of universal application, and not on any peculiarities of English jurisprudence." Since 1867, at least one judge from the Scottish system, now normally two, has been appointed to sit in the final Court of Appeal, originally the House of Lords and now the Supreme Court. But much damage was done between 1707 and 1867 and thereafter, to the extent that today Scots law can accurately be described as a mixed system with Roman law roots heavily overlaid by imposed doctrines and procedures of English common law. Today, the Supreme Court normally sits as a bench of 5, and so, even if both Scots sit in a Scottish appeal, they are necessarily outnumbered by judges trained and qualified in a different system. What conclusions can be drawn from all of this? When we look at the facts, at what happened to the executive, the legislature, and the judiciary, the orthodox view of 1707 collapses. Scotland's government was abolished. England's government continued. Scotland's parliament was dissolved. England's parliament was simply expanded. Scotland's distinct legal system was subordinated to an English-dominated final court of appeal. The evidence points to only one conclusion. Scotland was annexed into a continuing English state. It was not a union of equals, but the absorption of a smaller, weaker nation into a larger, more powerful one. Today, Scotland's status is not that of a partner in a union, nor a component part of a new unitary state. It is, in effect, a territory with limited self-governance, annexed by a larger country, and with its resources, including its abundant carbon-based and renewable energy resources, exploitable and exploited by the larger country for its own benefit and purposes. Understanding this history is crucial to understanding the political realities of today. The story of the 1707 Union is not one of a voluntary mutual partnership. It is a story of annexation, absorption, and the enduring consequences that flow from this. And this is critically important when the assertion that Scotland is not a dependency or colony of England today rests entirely on the representation of the Union as a voluntary partnership. What occurred was a takeover of Scotland by England. Views may differ on whether that takeover was hostile or friendly, but a takeover is what it was. Thank you.